Hello everyone, I am Aparna Chandra of Sri Ram Sarup Memorial University and I am an intern at All India Legal Forum. Today, I would like to discuss the case of Navtej Singh Johar versus Union of India. There is one quote which says, I am what I am, so take me as I am. This quote clearly defines that quality of a person what really matters, rather by the name or gender which he or she called. But there is certain sections of our society who are still living in the bondage of rigid norms. Social exclusion, identity seclusion, and violation from the social mainstream are the still dark realities faced by the individuals today. The natural identity of an individual is absolutely essential to his being because what nature gives us is natural. Thus, the part of the personality of a person has to be respected. Section 377 of IPC imposes criminal liability on anyone who voluntarily has carnal intercourse against the order of nature. This case challenged the said criminal liability for sexual relationship between consenting adults. The issue of criminalization of Section 377 of IPC legally arose in 2009 when the Delhi High Court in the case of NAS Foundation versus Government of NCT of Delhi observed that Article 15 of the Constitution prohibits discrimination on various grounds including sex. The court declared Section 377 unconstitutional on the grounds of violation of Articles 14, 15 and 21 of the Constitution of India. But this judgment was overturned in the case of Suresh Kumar Kaushal versus NAS Foundation, wherein it was held that prohibition of acts under Section 377 only regulated sexual conduct regardless of a gender identity and sexual orientation of a person. Section 377 would apply irrespective of age and consent, for the section did not criminalize a particular people or identity or sexual orientation and only identified certain acts which when committed would constitute an offence. Arguments by the petitioner. The petitioner contended that homosexuality, bisexuality and other sexual orientations are equally natural to all persons and are founded on consent of two legally qualified persons. These orientations are neither a physical illness nor a mental disease. Making the sexual orientation of a person criminal was offensive to the well-established principles of individual dignity and autonomy, and that sexual orientation is an essential attribute of one's privacy. The petitioner argued that lesbian, gay, bisexual and transgender community comprises 7 to 8% of India's population and they need to be recognized irrespective of their minority and they need legal protection. Section 377 violates Article 14 as it is vague regarding the term carnal intercourse against the order of nature and no reasonable classification exists as long as sex is consensual. Section 377 is contrary to Article 15 and has a chilling effect on Article 19, Clause 1, Subclause A, as LGBT persons cannot express their sexual identity and orientation freely. Sexual autonomy and the right to choose a partner of one's choice is inherent under Article 21 of the Constitution. Arguments by the respondent. The respondent state argued that the LGBT community is a statistical minority, hence did not warrant any specific law, policy or regulation. Judgment given by the court. The court decided that Section 377 violated Article 14, guaranteeing the right to equality because there existed no intelligible differentia. The court observed that what is natural varies from time to time, especially in today's time when sex is not only equivalent to generation of offspring. With regard to violation of Article 15, the same contention stands true as well because sex is the term at which sexual orientation and genders are defined. Article 15 has perpetually been assumed stereotypical of sex as male and female and heterosexuals. Thus, Article 15 must cover in its ambit the LGBT community as well. With respect to Article 19, the court decided that such expression of sexual orientation does not violate decency or morality because these concepts are not in majority. The challenge section also violated Article 21 for the right to life includes right to privacy of consensual acts and right to choose a sexual partner irrespective of the either party's sex. Sexual autonomy is also to be in the ambit of Article 21. The aspect of right to privacy was upheld in the K.S. Puttaswamy case is also an important point of consideration. Thus, keeping in view the constitutional rights of a citizen, they must be extended to the LGBT community as well. The Supreme Court based its judgment on the aspects covered in the above analysis and decriminalized consensual sexual acts of two adults and termed the act as natural. The Supreme Court held that sexual orientation forms a part of the right of expression under Article 19 and is an important part of the right to privacy. The Navtej Singh Johar case is a great win for the LGBT community in that homosexual acts have now been decriminalized.